For Monday, your lordship.
Why? What is the urgency?
Because there is urgency in the matter, because the stone crushers have been ordered to be terminated. License of the stone crushers have been terminated and ordered to be closed, your Honor.
Not Monday is not. 22nd January.
My lords, memo to
Serial number 51. The release is infrastructure, license already.
51.
Final memo.
51.
51, serial number 50.
Is a contempt petition? Yes. PA.
License was opposed, but license has been granted.
What is landed?
The license,
License.
CH-7 letter with license. So old matter, dependency, during dependency, it has become infirm.
Where is the name? Learned advocate Mr. So-and-so, so-and-so.
no copy.
Files. Second copy. No more stating that prisoner is not pressed. Dismissed as not pressed. The petition they go on the PI. So what happened to license?
License.
License is working.
License is granted.
Fifth point is comfortably running. What happened to all that, my lord?
Now
Happened
license,
to us in Karnataka.
license is granted.
License is granted.
Then how can you wait?
That's what. Not to grant. The petition was not to grant,
Now it is granted.
it is granted. What happened was that, my lord, Karnataka. What happened is that, my lord, in Karnataka, there is a ban for granting of fresh licenses. Then the government,
Your grievance stands, it is not satisfied. PIL.
please,
So still you want to withdraw.
please, my lord,
Your grievance is not satisfied. On the contrary, it stands.
yes. The grievances have become infectious.
My lord, license and CL-7 license has already been granted. And my lord may see the writ averments, they are all very vague, except for the names of a few CL-7 licenses. Doesn't survive for consideration now.
If government is opposing the withdrawal also, I can argue also.
Opposing the withdrawal, please don't.
What happened is, the government has banned the grant of licenses of other categories. They introduced new category of CL-7 in a hotel and lodging house. As a result, huge corruption, all these things because it has become infectious.
My lord, he may be permitted to withdraw.
80 lakhs is the bribe amount for one license. I'm not, because I'm withdrawing, I'm not canvassing it.
He may be permitted to withdraw
Please.
because the license to CL-7 has already been granted.
Will say new of the memo dismissed as withdraw.
Please.
Obliged.
My lords, I'm filing this memo for posting on Monday. We'll withdraw the matter, my lords.
Which one?
RP 420 of 24.
Listed today?
No, my lords.
15th. 15th at 2:30.
My lord, that's I'm seeking for an adjournment in serial number 24, my lords, contempt matter. So there is some inconvenience, my lords.
Yeah, contempt
Have it
matter.
in the next week or.
Go to then now,
Serial number.
17th February.
My lord, serial number 18, my lord, for adjournment.
Lord, serial number 46, lords, may kindly be connected along with the another matter and be taken up along with that.
So 46, it was requested by learned advocate Mr. So that this contempt petition may be listed along with.
CCC 909/2020.
Why? Why?
Because it is similar already that has been, it is being dealing with, my lord. There are other connected matters, so this also is the similar matter.
It comes before this bench.
It comes before another bench, my lord, because this is 2023 matter.
Can you file some
It
notice?
was
for
coming
that?
here before.
There will no judicial, there will be no ready judicial order.
Similar matters. There are other connected matters, my lord, which
Then
come
go
before this one.
Apply to the register judicial, and then on administrative side, we'll see whether this will go there or that will come here.
Please, my lord.
My lord, serial number 18, my lord.
18.
2 weeks, it may be. I am the K waiter, my lord.
46 we are adjourning, Mr. to 18th of February. In the meantime, whatever you want to do.
Please.
Yes,
My lord, serial number 18, my lord.
18.
2 weeks may be adjournment. I am the K waiter matter, my lord. Senior is out of station. On 2 weeks may be granted, my lord.
My lord, serial
My lord,
number
my lord, 2
47
weeks.
is also same.
Barcode.
Serial number 47 may also be adjourned along
One
with
is also same.
46
That will
and
also
47.
go to 7th end.
Please.
17th February.
Serial number 44, my lord.
The preliminary petition, 17th February.
Serial number 44.
44.
Office objections along with counsel submission. Office objections along with counsel submission, madam. Accused number 2 is not a party before writ appeal, but he is a special tahsildar, my lord. He is a necessary party, my lord.
We'll see.
Or
Let it be called out. No mentioning for sir.
much.
Any mention through VC, sir? This list one, so contempt fresh matter, still number 1, to Kantaraj V.
For petitioner in this case, the petitioner is filing memo withdrawing this one, the subsequently they have complied with the order.
Governor David, Mrs. Swansea files a memo dated Swansea.
The respondents have complied with the order
Which
of
is
the writ petition.
The memo states that since the order under contempt is complied with, it is not required to prosecute it. In that view, petition is dismissed as not surviving.
Still number 2, to Keshav Murthy B. Still number 2, to Keshav Murthy B.
So it will go to 16th.
Still number 3, the Ardhana Murthy.
That's, representation has been considered and endorsement has been issued. Madam. Similar orders have been drawn. Passed.
22 order of 2022. This petition is filed in September 20. What is you complied with?
Please consider their representation. Please, my lord.
Very good.
My lords, affidavit has been filed, my lords, and it is at
The only
page
direct
7.
order of law in a single judge goes to require the authority concerned to take.
I'm seeking liberty to challenge it.
To require the respondent tahsildar to consider the claim of petitioner and pass appropriate order in stipulated time. So when the contempt petition comes up, it was pointed out, it was undisputedly pointed out that the competent authority has taken, where is that?
My lords, page 7, my lords, endorsement dated 28/2024.
There is no such. You put it in the compliance of read is filed, along with which endorsement will be order dated blank 8/24 is passed by the tahsildar, rejecting the request of the applicant. In that view, there is a compliance. The contempt petition does not survive. Full stop. If the plan is agreed by the
My lords, with liberty to challenge the very.
liberty is reserved for the petitioner to institute independent proceedings as may be permitted in law. In respect of it, this court does not accept the opinion on merits. Yes, next.
This is number 4, to Rupesh V.
Appear for petitioner, my lord. Annexure C, page number 34 is the order of the Leonard Single Judge, my lord. Positive direction is issued to my lord. Enter the judgment passed in OS.
Is for March.
The PL matter seal number 5.
Petitioner, my lords, Lord, on earlier occasion, my lord, issued a direction at page 116 at annexure J, my lord. 117, your lordship, my lord. 117 annexure J. Accordingly, my lord, we have submitted a representation to the authorities. As per your lordship's, my lord, the direction. Instead of considering, my lord, the case under the Land Revenue Act, because it's a purely a violation of, my lord, unauthorized, my lord, mushroom growths of, my lord, the lands and, my lord, the buildings. My lord, instead of that, the endorsement is issued, which is contrary to, my lord, the direction. Our pure case, my lord, is that the unauthorized construction of buildings and grant of, my lord, the licenses for construction. Instead, my lord, the deputy commissioner and, my lord, the endorsement is at page 141. My lord's direction is at, my lord, page 120, it starts. Quite contrary to your lordship's, my lord, direction. Instead of examining the issue under the Land Revenue Act, the unauthorized construction of the buildings and, my lord, establishing shops and commercial establishment.
How you are concerned?
But I have come up before your lordship's, my lord. He is also a resident of the earlier your lordship, my lord, page 117. That I have established, my lord, a brick factory and also a public, my lord. Those things have been examined by my lords at the time of, my lord, the first writ petition filed before the
What
lord.
is being constructed? Some commercial complex.
But I am not constructing, my lord. The unauthorized construction of buildings in agriculture and revenue lands and, my lord, giving licenses. They have not followed the, my lord, as laid down by the under the Land Revenue Act. And your lordships has examined and issued a direction to submit a representation to the deputy commissioner. Instead of considering that, my lord, under the Land Revenue Act, he has rejected at the to approach the excise authorities.
Next, the RAM is under challenge. What is?
Both the matters are interlinked with regard to the license premises and the grant of license.
License to?
My lord, for grant of CL7 license, my lord, both are interlinked with regard to the license premises, my lord, for which license is granted, my lord, and the grant of license. Now, the deputy commissioner has said that they have to get the conversion of these agricultural lands into non-agricultural purposes, and thereafter, my lord, they have the blueprint of the proposed license premises, and thereafter, my lord, the CL7 license are granted. That is interlinked. Both the issues are interlinked. And the deputy commissioner has considered that, my lord, in page 145.
Here on 140.
Yes, in the endorsement, internal page 3. If the petitioner is aggrieved by this, then he'll have to file
found fit to be granted in accordance with law.
Please, man.
That is, it should not be near a school, temple, so many other conditions are there. Now, each case will be examined on its individual basis,
Yes.
and the jurisdictional officer will be granting the said license. Now, you have filed one PIL for asking your relief is pretty vague. It virtually amounts to issuing a direction to the authorities concerned that they have to grant license only in accordance with law and not contrary to the law.
That is, my lord, with great respect under the Excise Act. The lordship is right, my lord. My concern is, my lord, the unauthorized construction of buildings in revenue lands and in agriculture lands. He has to examine under the Karnataka Land Revenue Act 1964.
Sir,
Instead of that, now he has relegated to the under the Excise Act before the Excise Commissioner. Your lordships, my lord, on the
Listen,
earlier occasions.
Your representation to the authorities concerned pertained only to grant of liquor license.
My lord, including your lordships as per the direction of this court, my lord, your lordships on the earlier occasion, page 117.
The counsel, each individual case when it crops up, you are required to challenge it. A blanket order cannot be passed, number one. Number two, we cannot presume that the authorities are necessarily going to commit an illegality.
Great respect. On the earlier occasion, your lordships, my lord, kindly go to my lord, your lordships, my lord, you have at page, my lord, page 120. My lord, page 109, it starts, my lord, para 3 of the earlier proceedings. It is stated, may I read your lordships, my lord? Page 119, my lord, 119. Pursuant to this order, my lord, I have submitted representation. May I read your lordships, my lord? 119. Annexure J. It is, may I read your lordships, my lord? Para 3. It is stated by the petitioner that he come across several deficiencies in functioning of revenue department, and agricultural lands are allowed by the department for the purpose of building houses. It was submitted that especially in Kolar and around Kolar district, the land were utilized for non-agricultural purpose without conversion orders. The next matter 3.1. The second limb of the grievances appears to be that permission is granted to several sites by the revenue authorities for opening a liquor shops, which according to the petitioner is done under the garb of CL-7 licenses for boarding and lodging. 3.2. With the such basic premises of the action, the grievance of the petitioner has paid for. 3.3. It is also stated by the petitioner making part of the prayer with regard to the grievances as aforesaid representation dated 4/3/24 was made to the principal secretary, Revenue Department, separate representation also given to the Deputy Commissioner Kolar. However, no action was taken. The basic grievances of the petitioner is that the pockets of the agricultural lands are permitted to be utilized for commercial and non-agriculture purpose. It is also the grievances that certain sites are permitted for utilizing to run liquor business, which again is not in accordance with the provisions of the law. The allegation made in the petition are serious, but are too vague to be construed by the court by entertaining the public interest litigation. The court may act only if there is a specific instance making out a cogent case. It is noticed that the petitioner had made a representation to my lord. This is the cause of action. Para 6. The petitioner is permitted to pursue the representation, and if any specific instances.
Now, his grievance is at page number 166. This is what his contention is. This the government has to clarify. That's all.
So these are omnibus petitions. Two general.
My lord,
That's
please
the
see the rule 5 of the Karnataka excise sale of Indian and foreign liquor rules which pertains to grant of license.
Sir, your grievance is at page number 160. second paragraph. That's all, no?
160, my lord.
Yes, 160, translated copy.
The placement. Placement. This is, my lord,
That's your grievance.
as per the direction of your lordship.
That's your
my lord,
grievance. Your grievance is in second paragraph. And direct local urban development authorities to take appropriate legal action under the Urban Development Acts against the sanctioned charters in unauthorized buildings constructed without building plan approval from the local urban development authority. That's your grievance.
Placement.
That's all.
This is what also. Sorry, dismissed.
Obliged.
Till number 6.
My lord, in this matter, my lord, the learned advocate general seeks for a short accommodation till the 15th, my lord.
What is it about?
My lord, this is the Kambala matter.
Kampala.
Ah. Ambala,
Yes,
then. 21st,
15th, my lord.
21st.
My lord,
20
short date may be granted, my lord. Kambala season ends
21st will not do.
short.
My lord, my lord, 18th, then, my lord.
18th.
Obliged.
Much. My lord's 18th, there's some difficulty. We're being led by Mr. Chinnappa. There's some difficulty on 18th.
Very well, 17th, my lord, my.
17th.
Oh, 17th, no, my lord, that's a Friday. I'm looking at the wrong.
17th and 18th, there's some difficulty.
Very well, my lord, 20th. I'm obliged, my lord.
I have, my apologies, my lord. Again, 20th also, I have a personal difficulty that week. My apologies.
21st last, no change.
Obliged, my lord.
Thank you, sir.
So green bench matters, till number 7. So Manjunath D. Kandekar.
Same matter, 7, 8, 9, same matter. sir.
Okay. My-
That registration, 15B. Same.
Same number. 7, 8, 9, my lord.
All left. Disposal. Madam, same.
Yes, my lord.
What's your blessing?
Still number 10. To Narendra SS.
I appear for the petition. The challenge is to demand notice, not in the similar challenge your lordship was pleased to grant interim orders. The cluster of leases.
Interim order.
Yes,
Upon payment of some amount,
yes, 7 lakh.
7.5 lakhs.
Quote of.
But that will just check of similar.
Same
Yes,
survey number, Lord, it is adjacent lease. And it is on a non-existent demand.
What is sought to be called in question by the petitioner in this petition is order dated 21/6 by demand for penalty of rupees 13,80,88,749 is put forward by the authorities against the petitioner. Learned Mahendra for the petitioner submitted that subject matter dispute is identical to one involved in writ petition number 30419 of 2024, in which order dated 3rd November 2024 was passed.
Here, Lord, there is no order of attachment.
Comment, advocate was not in position to controvert the actual position that both the petitions operate on similar heads and issues. In that view, paragraphs. Similar order deserves to be passed in the present petition as well. Paragraph notice returnable. Paragraph 4. Same.
My lord, in this, there's no order of attachment, just the notice that has been
No order
issued.
of attachment.
The
My lord,
notice-
your last make grant.
Notice returnable. So notice is required to be issued in this petition also.
Yes. Page
Notice
85.
returnable on. When shall we keep?
My lord, similar order may be interim order may kindly be passed. My lord.
What interim order?
Because my lord, as per Annexure D, they are initiating revenue recovery proceeding.
My lord, based on, my lord, as on date, I have no information with regard to initiation of recovery proceedings. My lord, this notice has been upheld by the order passed by
Only
the
not-
government and in
Only-
exchange.
No, I may be permitted to submit, my lord, because here, my lord, the very initial notice has been withdrawn by the government by 4 circulars, which I have argued in the earlier occasion also. Accepting that, my lord, your lordship was pleased to grant interim order. The notice under challenge produced at Annexure B.
There is no action as on date which is to be prevented.
Not only that, my lord, your lordship accepted my contention that Annexure B has been withdrawn by the government.
My lord, that is his contention, that is his argument. I have no
Your
such
lordship may kindly
instruction.
see
They
in
are
the
saying
earlier
that-
order also.
They are saying that there is no action taken which is to be prevented by interim order.
No,
Lord,
no, my
your
lord,
lordship may kindly peruse Annexure D, Annexure D,
Annexure D.
D, page number 113. Page number 113, in connection with the so and so, para 2. Further, as per the order of Honorable Karnataka Lokayukta so and so, and demand letter issued by this office, a penalty of rupees 14 lakhs so and so was paid to be paid concerning quarry lease number 920. Against this, the government received revision application. After review of the same, the government issued an order, reference number 4, dismissing the revision application and instructing recovery of penalty from the quarry lease holder. The relevant portion of the order is as follows. The revision application along with IA number 1 and 2 to the said revision application are dismissed for the reason stated above, and the respondents are to proceed for recovery of penalty and other amounts as per law, so as not to cause further loss to the state government. Blood, during the pendency of revision also, I was enjoying interim order. Hence, as per the government's revision application order based on 2023-24 financial audit report, the arrears of
Notice returnable on 24th February. Since it is the contention paragraph on behalf of the petitioner that the entire demand is without any factual basis. Inasmuch as no assessment process is undertaken, the respondents' authorities shall desist from taking any coercive steps, provided.
my lord, interim prayer and main prayer is one and the same. My lord. Interim prayer may be seen.
no, it is not one and the same. We are seeking quashment of the entire demand.
We have to give. No coercive steps shall be taken pursuant to the impugned notice, provided that the petitioner deposits rupees 7.5 lakhs towards the demand before the returnable date.
But we have said deposit of certain amounts. So should we say that? Here we have said deposit of certain.
7.5 lakhs.
My lord, that's peanuts for before 13 crores, my lord.
So shall be deposited with the authority concerned.
Sorry, madam.
You pay the amount, deposit the amount with the authority concerned.
Sorry.
Not before the registry of this court, but to the authority. 7.5 lakhs.
Please, madam, I shall.
Government,
My lord.
see, in these matters, on two grounds you can initiate proceedings.
Yeah.
Number one, they have mined in an area where they do not have the authorization.
Yeah.
Second, they have mined excessively
Yes.
beyond the permit granted to them. Now, you need to produce records to that effect.
That's the only issue. my lord.
That's the issue. That is the crux of the issue.
Obliged.
So we'll conclude the matter once you.
My lord?
Since there is a question of demand of penalty and revenue, will.
Lord, here 1.32 acres. They are demanding for 1 year, 13 crores of excavation of grey granite, which is humanly impossible to excavate. Next.
Obliged.
Number 11, Shivaldi. Lord, a petition or has challenged a notice dated 8/2/2024. Not similar notices were challenged in other petitions. Lordships, day before yesterday, Lord, the notice is not demanding rupees 3 crore 58 lakhs without not inquiry, without opportunity and all. This is also identical matter. Pass this.
We don't know. You are saying that similar, let us see. Yesterday's matter. No, not
Three
yet.
matters were listed. Not yesterday, not just 2 days back. This is a notice at annexure F, page number,
Treated
40.
stock also.
please.
Yes.
Well, I will pass the orders.
Treating the
get it
notice
on-
as Shoka's notice and permitted me to file a reply to the authority.
Yes, same direction.
Please,
You get the order on 15th.
please. This. So writ appeal matter, so seal number 12. Giri Kumar SV, seal number 12.
It can go to some other date. You are there?
Yes, sir.
Yeah.
Notice has to be issued.
Pardon?
Notice has to go. The first time coming.
What is the matter? Appeal is there? Delay? No.
No
12.
No delay.
So what is the issue? How you are agreed?
But I was working in the government for more than 32 years, sir. And as per the apex court judgments and observations and all, my lord, I was supposed to regularize a permanent government employee. But they have categorized me under a daily wage employment, and they have put me in a daily wages act. So that is how I'm aggrieved. And the impugned order, my lord, states that the endorsement which has been issued has been accepted by the.
My lord, attained the age of 60 years on 30th January 21, my lord. The termination benefits, my lord, of rupees 5,62,000 was paid and accepted by them, my lord. That was paid under the Karnataka Daily Wages Employees Welfare Act.
Yes, my lord.
Therefore, my lord, the question of regularizing them at this point of time does not arise, my lord. They are seeking for regularization of service, my lord. The age, they've attained the age of 60 years and accepted the termination benefits as well.
So put that fact amount.
Please, my lord. Please, sir.
Learned the additional government.
Notice will be issued.
I'll accept notice for all respondents.
Mr. Harish accepts notice on behalf of all the respondents and wants to file reply affidavit. He has stated that the appellant is already at the age of superannuation.
Age of 60 years, my lord, and accepted the terminal benefits.
Tend over to 6th of March, within which time the reply shall be.
Great.
Number 13, state appeal. 13 is government appeal, my lord. There's a delay of 485 days, my lord, in filing the appeal.
Notice written
Yes.
4th March. Very long delay, 485 days. Anyway.
Number 14, Mr. Ramamurthy BV.
My lord, sir, counsel on record requested for a time minute. I'm a proxy. Further, my lord.
You have to go for some
3rd March,
lordship's
as
order.
requested by learned.
Lordship's order.
Lordship's
My lords, my lord, just, my lords, are against the my lord's order.
Not to be placed before the bench where one of us individual Mr. Justice. By your own bracket over his member.
Number 15. Yes, Saravan.
Fifteen is now, what is that? You are in 15.
It's a property which was not subject matter of acquisition. Rather, it was dropped from the acquisition, was utilized for which the compensation was claimed by filing a writ petition. The learned single judge, by a cryptic order, says there are disputed questions of fact. The BDA did not dispute the fact that this land was subject matter of notification, subsequently not included in the final notification. I'll take out notice minutes on the BDA because their objections were not on record. No objections were filed, minutes disputing any of the facts made in the writ petition.
Yes, sir.
What is written over?
Lordships.
When? 21st February? 21st February.
Number 16.
My lord, 16 and 16.1, my lords.
Dear respondent, I want a short passover, my lord. Can your lordship accommodate me at 2:30? In the morning, I have some inconvenience. I'll come and argue it at 2:30, my lord.
2:30 may not be possible because there is a bench and then some difficulties. 16 that can be taken.
My lords, may I make one request, my lords? He's senior to me as well, so I'll make that request to my lord, sir. Permit me to open the case, my lords. I'm requesting for some interim protection.
My lord, that's the whole thing.
If I don't make out my case, my lords,
I'm opposing any interim. That's a whole issue, my lord. Can I-
therefore, my lords, my senior is virtually here. I've come all the, not to sit. Lords, I'm from here, but I've come all the way, my lords, 1500 kilometers. Therefore, my lords, let me just open my case, my lords. I'll just place my facts, your lordships may consider.
My lord,
Now, the AG is here, my lords. The AG is opposing me as well.
I'm not opposing anyone, my lord.
No, if he's not opposing, then, my lords, there can be an interim protection. AG is for the KIADB, my lords. My primary case is against the KIDB. My esteemed senior, my lords, appears for the Allotti, my lords, which is a company in which I am, my lords, claiming to be a shareholder. Therefore, my lords, my dispute predominantly is with KIDB, my lords, not with my senior's client.
but the whole approach before the learned single judge was that they were seeking to enforce some right in the insofar as my client is concerned.
Correct. Therefore, let me open my case, my lords. I'll place my facts.
But therefore, my lord,
Monday Supreme Court is holiday, my lord. I think he's here.
No, no,
he is
Monday.
not right, my lord. My learned friend can take it up on Monday. My
No, I'm
learned
not.
friend.
Monday Supreme Court is on leave, my lord. So
That's
my learned friend can stay.
Hey, I'm not here, please. My lords, I'm the black sheep which has left the herd and gone to Delhi. They're dragging me back. It can't be, my lords.
16th, 15th or 16th, whichever from.
My lords, and would your lordships consider 16th, please, my lords?
Mr.
I'm
Raghav.
sorry.
Can it be on, if it is possible, on
17th. 17th.
so then 20th. 20th. Because I'm not in town.
All at 20.
Grateful.
You.
My lords, knowing all of them makes it difficult for me to oppose. That's the problem.
No, my lord, we know my learned friend is a very reasonable opponent. That is
I
why.
wouldn't have come if that indicated.
No, I didn't know this. I understand, but I'm sorry that I put a learned
No,
friend.
no, sir.
Yes.
Not at all, sir. 20th.
Grateful.
My lords, permission, of course, to appear virtually, my lords, on 20th. It may be difficult for me to be. I'll grateful, my lords. Next.
Number 17.
Lords, I appear in 17.
Banus.
Would your lordships give me 30 seconds, my lords, before any papers are seen, my lord, just to place the facts? I have been ousted from court. I'm challenging, my lords, an acquisition by the BDA. Please, for a minute, leave the factual matrix aside, my lords.
Technical snag is the 17 days delay.
No, in 17 days delay, my lords, but kindly see, my lords, I had an interim protection right through not to be dispossessed, my lords, from 2016 to 2024. 2024 October, the order is passed. Why am I ousted? I am ousted saying I am a subsequent purchaser. My lords, your lordships in two judgments hold that a subsequent purchaser is certainly a bar if I am challenging the acquisition proceedings on the process, because I was not the owner as on the date of the notification. However, if it is a scheme lapsing situation where under the BDA Act, the scheme has lapsed and therefore the entire development goes, then the situation of a subsequent purchaser is no bar, is a judgment of a division bench of this court, which is upheld, my lords, by the Supreme Court. Now, I am of a subsequent purchaser, I disclose it as a subsequent purchaser, but I challenge it on the ground that the JP Nagar 8th phase scheme has lapsed. Admittedly, it has lapsed because this court has held it to have been lapsed. Supreme Court has upheld it to be lapsed, but I am ousted saying you are a subsequent purchaser. Kindly see, my lord, just 3 paragraphs, my lords, I will indicate. Please permit me, my lords, to come to the impugned judgment. It's a very short order, my lords, 11 paragraphs. Please come to, my lords, page number 52. It starts at 44, my lords. I am at 52. My lords, at the 52 bottom, my lords, para 10. With my lord's kind leave, I will just read 2 paragraphs, my lords. On perusal of the aforesaid order passed by the High Court would indicate that there was a dispute raised by the erstwhile owners in so-and-so suit on apportionment of compensation. It appears that the petitioner herein has purchased the aforementioned land. It is also noted that the order passed by the court in so-and-so was confirmed by this court in writ appeal number so-and-so. Now, in the light of the aforesaid judgment, the petitioners have suffered an order before the learned single judge, which came to be confirmed by the division bench as referred to in so-and-so, and therefore they go to Delhi Development Authority of Manpreet, which is on subsequent developers, subsequent purchaser. Now, please see para 11, my lords, in the next page. It is categorically held by the Supreme Court and the High Court that committed an error in entertaining a writ petition wherein the writ petitioner, being a subsequent purchaser, has no locus standi to challenge the acquisition or lapsing of the acquisition. My lords, that last or lapsing of the acquisition is wrong. The learned judge, my lords, has put themselves in error because lapsing of the judgment, my lords, is not Manpreet. It is, my lords, Adikeshavalu Naidu, where Supreme Court says in lapsing of the acquisition.
Which is the judgment?
My lords, I have appended that, my lords, in the combined. Please give the combined. But just 2 judgments and 2 paragraphs in it, my lords. My lords, your lordships can look at the writ appeal itself. I have quoted it extensively in the writ appeal. Please permit me to come to my lords in the writ appeal. Page number, my lords, straight away. Page number, paragraph 68 in page number 37. Would your lordships permit me to read that paragraph, my lords? Page 37, ink page 37. Writ appeal, para 31. I have quoted, my lords, para 68 and 69 of Adikeshavalu of the Supreme Court, of the High Court. Affirmed by the division bench here. Adikeshavalu is in the Supreme Court. Sampangi, my lords, in Supreme Court has been affirmed by the Supreme Court. SLP has been dismissed. My lords, I am reading that paragraph, my lords, 68, 69. Please permit me to read it in its entirety, my lords, to put the focus. While to press home the preliminary objection was subsequent purchaser can't. Mr. So-and-so learned counsel for the BDA placed reliance on the judgment of this bench in Purna Prajna's case, following the judgment of the Supreme Court in Shivkumar Bhargava, and based on the principle that it is only a person who was the owner of the subject land at the time of issue of the preliminary notification who can either question the legality of the acquisition process or put forth a claim for alternate land or site so enabled. The subsequent purchaser will have to rest content with receiving compensation and even cannot question acquisition proceedings. Please see, my lord, next page 69. In the factual plane, the legal position in terms of section 27 of the BDA Act as to operate against the BDA, this is on lapsing of the scheme, my lord, as even long after publishing the final notification under 29(1), the scheme had not been implemented, much more than 5 years having elapsed from the date of the issue of the final notification by the time the petitioner purchased the site, and therefore the possibility in law being lapsing of the scheme had been propounded by the BDA, the situation factually and legally being quite different from what was examined and found in Pura Prajna's case, the ratio of this case is not applicable, and on examination of these rival contentions and on the touchstone of the statutory provisions, I do not find the present situation in undoubtedly one where the ratio of the decision called out in Pura Prajna and the ratio found in Shivkumar Bhagat Supra is not attracted, and therefore the preliminary objection does not come in the way of examining the action of the order of the BDA and the state of Karnataka. Having said so, that its scheme lapsing is upheld. The same scheme, my lord, I'm not even talking of a different scheme. Same scheme, same JP Nagar 8th phase, the scheme is held to be lapsed, my lord, by a single judge division bench and subsequently in Sampangi by the Supreme Court. My lords, I've had all the prayer is I'm seeking is this, my lords. There was an order by your lordship's court, my lords, a single judge, my lords, in 2014 saying I should not be dispossessed. They have not dispossessed me till now, my lords. I'm only seeking, my lord, that protection continue with me, my lords.
Or learned senior so-and-so, assisted by learned in the writ petition. The appellant petitioner lodged challenge to preliminary notification dated 23/3/1988 and final notification dated 19/10/1994 on the ground that the acquisition had lapsed in respect to the land of the petitioner. On a single judge has refused to entertain the petition and dismissed the same on the ground that the appellant petitioner was a subsequent purchaser. Learned senior advocate would submit with reference to the decision. Where is the decision?
My lord, it is in page number 37, my lords, of your lordship's paper book.
Decision the Supreme of the Karnataka High Court in the R. Adikeshavalu Naidu versus State of Karnataka, 2011 SCC online, Karnataka 197 bracket over, that the bar contemplated for subsequent purchaser to challenge the acquisition will not be a good ground to apply in the cases where the acquisition has lapsed. There shall be notice to the respondents returnable on date. 10th March,
Please.
10th March. What is the interim relief?
My lords, I'm only seeking status quo as it prevails today, my lords. They have not dispossessed me, my lords. The fact is that.
Paid interim relief, the parties are directed to maintain status.
Please.
With regard to the subject.
My lords, may I show the previous order? Give me. Which
It is not allotted,
my lords?
not allotted to anybody.
I'm sorry,
Not allotted to anybody.
no, my lord, not allowed. My lords, what happened was this. I'll just place that fact. About 1,000 acres of land was acquired.
We'll record your statement.
That, my lords.
That not allotted to anybody.
Certainly, my lords. In fact, my lords, it's 1.5 acres of land. It's not even touched.
Was supposed to be stated the site, it is site.
No, my lords, it's about 1 acre and 5 guntas of land.
Land in person is not allotted to anybody by BD.
Please, my lords, your lords.
Supposed to have in that view, the party, by of paid interim relief, the parties are directed to maintain status quo as on date during the pendency of the appeal.
Please. May I request status quo as on date of the writ petition? That's the order that was given to me. I'll just show this language, my lords. I'm not troubling your lordship. Just to persuade my lords, please see the order that was passed to the writ petition.
If it is operating,
My lords.
that order is operating.
That order operated till the final order, my lords, in 2024. And that order was, my lords, that I should not be dispossessed. Specific order. I'll just show the language. Kindly see this, my lords, and I'll not trouble your lordships further.
My lord, regarding the current state of the BDA, may I have to go submit before the court about the allotments and the current
It
status
will only
regarding
say
the
the parties
possession?
shall maintain status.
Please, ma'am.
Please.
Nothing more.
Grateful, my lords. Grateful for the opportunity.
Let us go with regard to subject matter land.
Well, delay of
No, all are government authorities.
Pardon, my lord?
delay, my lord, 17 days in which 7 days was
Notice
for
has to go to
certified.
BDA, my lord, on delay.
Then
no,
how
delay
can
can
we deal?
17 days. delay.
17 days in which 7 days is for certified copy being given to me late, so effectively 10 days.
That is all like technically, how can we grant interest?
No, my lords, your lordships have, my lords, on that may I make one submission. My lords, the fact that there is a delay, my lords, does not prevent my lords jurisdiction to give me interim protection, my lords. Certainly not to allow the writ appeal. Because they are here, standing counsel is here, my lords.
Who appears?
I appear for the government, my lord. Let them
BDA?
serve on the panel council for the BDA and
Who appears?
from BDA they can
Any-
to the panel council, my lord.
Charati appeared.
Karate,
Mr.
previous
Charati-
matters, my lord, they appear.
Mr. Charate appeared immediately in the.
You are there. Accept the notice.
My senior appears for BDA, my lords.
So we'll directly accept the notice. We condone
So
the
delay can be condoned.
I'll have to secure instructions, my lord.
Vachan appeared.
Please.
Okay.
Please.
You are in panel.
My senior is on panel, my lord.
So in CA, this application is filed seeking condone the delay of 17 days, which is filed, which has occurred in filing the writ appeal, having heard learned advocates for the parties, the accompanying affidavit makes out a sufficient cause to condone the delay to the extent of 17 days. Delay is condoned. So in the beginning, learned advocate versus so and so is directed to appear on behalf of BDA and accept the notice in the totality of facts and circumstances.
I'm very grateful.
Also, learned advocate with so and so.
I'm representing respondent state, my lord.
And learned advocate to the respective parties, waives notice in this application and then order.
Copies of the appeal memo.
Of course, I'll serve it right away. I'm so very grateful.
The 18 urgent. Urgents, number 19.
I appear for the petitioner, my lord. In this case, reply had to be filed by the state.
My lord, I seek my lord's apology. I pray for some time, my lord. This pertains to, my lord, conversions of land based on the, my lord, technical committee under the chairmanship of the Deputy Commissioner Revenue, where agricultural lands, including Jamma lands, had been, my lord,
Noted.
converted for non-agricultural purposes. And my lords had on My lord, 711 passed a detailed order. My lord, I've not received any instructions, my lord, and besides it has a,
At the request of learned additional government.
Interim order
Okay.
mechanisms.
3rd March,
obligement.
Interim order mechanisms.
interim order operating is limited.
My lord,
It is limited.
no, my lord, oh, but only to that particular.
No, interim order is limited.
Yes, my lord, it is limited.
Interim order operating already granted. It should not. Possible will not. And during pendants, that is what my,
No, my lord, it is, shall continue, it is.
not necessary to it.
Much obliged.
This number 20.
And for the petitioners. The petitioners are seeking the license for quarrying in terms of on the ground of parity. The Lordship at Annexure B, page 84, Lordship may kindly see the license. The petitioner, along with this person who has been granted license, had approached earlier before this honorable court, and as per Annexure D at page 98, my lord, it was disposed of, and there is a further direction. The Lordship sees at Annexure G, page 184 to 189.
Reply is filed.
No, my lord, I seek for some time because,
So
my
last
lord,
time,
there are objections.
times they have
my lord,
taken.
they are
Only on the ground of parity. If your lordship sees page 184, in furtherance of the direction, the similarly placed person has been granted license. There is no impediment. All clearances have been obtained, and it's a saved application. All that your lordship may see the prayer. It's all, that's all, my lord. Earlier twice we have approached this honorable court. Now in
Since there is
furtherance.
an order, why you are become slow?
My lord, it comes with 10 kilometers within the wildlife area, my lord. That's
Same
the
survey
reason
number,
why.
my lord. Annexure B, I have produced.
File it. You have become slow in filing reply.
Pardon me, my lord?
You have become slow. Government has become slow in filing reply.
My lord, instructions have to come, my lord. I'm not slow.
Lordship, twice it is spoken.
I apologize if my lord has.
Because it's on the ground of parity, I don't think.
29th January.
29th.
Ganpati, but
This case, previous date of hearing, this honorable court directed government to produce, my lord, records. Here, my lord, there are twice it is directed. I have made an application for grant of quarry lease as per Annexure A, measuring 6 acre, my lord, in survey number 105 P1, situated at, my lord, Paradi village, Beltangadi Taluk, my lord, South Canara district. Then, my lord,
Yes.
My lord, I wasn't called upon to file the record. My lord may see the order dated 14/11/2024.
But then it is noted that to somebody you communicated that.
It's a deemed forest that I have.
no, kindly see 104, my lord, page 104, which they have issued. Your lordship referred in the order also, my lord. Kindly see
That's
in
fine.
page number 104, that is, my lord, order passed by the my lord, Revenue Department. Para 3 may kindly be seen 104 translated copy. The proposed place, whether it is recorded a forest in the revenue records as per the government notification, so also dated 1/5/2014. While considering the current RTC of the land and extent of 9.57 area in 105(1) of the Paradi village, Baltangadi Taluk, that is being recorded name of the government, but not made entry as forest. And further proposed that it is the distance from 248 meters from the forest ave. Therefore, my lord, that they have, apart from that, I have produced notification before this honorable court. That is a part of record, that is government notification regarding deemed forest. That is, my lord, starts from in page number 53. This has been referred by this honorable court, and no objection has been given, and this is not notified. Entire notification Annexure F that I have produced. Idrallu kuda that notification, this survey number has not been found. Therefore, your lordship directed to, my lord, produce records.
My lord, the issue that was there before, that has to be, my lord, resolved is, my lord, his application was rejected on 2/9/2014. My lord, after, my lord, 9 years, 3 months, he files a revision before the joint director, which my lord gets it at page 109.
That is the crux of the issue. Therefore, my lord, that order which is passed in the year of 2014 has been served or not has to be ascertained by this court.
Now,
Therefore, record has to be directed to file before this court. That has not been served. That is my specific contention.
first submission is that whether it is deemed forest or not. Now, when I make a submission, they say.
So kindly, my learned friend may kindly be see the order, that which I have not suppressed. Kindly see annexure D.
Put something on record instead of orally submit.
Very well, I will do that. If necessary, I'll produce the record before my lords. My
Annexure
lord,
D, my
and,
lord. That they have said this is a forest land.
They will produce in
Please, that is what your lordship directed to produce entire record.
30th January.
yes, I'm obliged.
So we will take.
My lord, on two issues, my lord. First is whether it is deemed forest or not. Second is whether it has been served or
Sir,
not.
that's all.
That's
That's
the
all.
two issues.
That's all.
Not elaborate and then call upon me to.
Definitely, entire file may be produced and my lord.
So we are taking 15 minutes break
Oblige.
Please,
for some reason.
great.
Cell number 22. Ravindra Gajanan.
Please, my lords. In this writ petition, my lords, petitioner was having a query lease valid till 2037. And genesis of the case starts with the issue of a show cause notice by the revenue inspector alleging that certain extent of land from tank bed area has been encroached upon. That order, that show cause notice came to be quashed by this honorable court, and the relevant portion of the order at page number 55 may kindly be seen, my lords. Page number 55. I may kindly be permitted to read. The writ petition is allowed. The impugned show cause notice dated so-and-so issued by respondent 5 is hereby quashed. Third, respondent number 2, Deputy Commissioner shall hold an inquiry against respondent number 4 and 5 and report compliance to the registrar of this court within a period of 3 months from the date of receipt of certified copy of this order. Still, such a, to the best of our information, such a report has not been filed by them to the registry, my lord. So, continuation to that proceedings, as a counterblast, that revenue inspector files a criminal complaint before Kodihalli police station, which also came to be stayed, my lords. That is produced at annexure D at page number 56, and interim order is still operating. And the third step now, this present proceeding is initiated, permitting me to generate computerized mineral dispatch permits through ILMS mode, integrated lease management system mode. I have been carrying this activity for the last 17, 18 years without any issue of notices for any of the alleged violations or terms and conditions of the lease, my lords. Every year I have been, my query lease has been audited with the technical officers, and they have certified that there is neither arrears of royalty nor any violation. And now this kind of notice has been generated just to harass this petitioner through political.
You have produced 20/12/24. That is the basis for closure of blocking.
No notice has been issued to us. No show cause notice has been issued.
My lord, please take,
Available or not?
my lord, please take paragraphs 7 of the writ petition, my lord. Internal page 13. A representation is given to us on 2/12/2024, based on which we have issued an endorsement, my lord, which I have produced it along with the memo on 8/1/2025. And my lord may see the endorsement, internal page 3 of the endorsement, paragraph 2. They admit
Endorsement.
they have encroached, yes. There are violations.
That we have seen.
The representative of the petitioner himself admits.
This endorsement is appealable or not?
It's appealable, my lord.
Sorry, my lords. It is not an endorsement which has been issued in accordance with law. This deputy.
My lord, this endorsement has been issued requesting, my lord, the director to take further action.
You have to challenge this.
No, my lords, it cannot be said to be an endorsement by a competent authority. Competent authority is the director. And such a submission, I'm very sorry to say that, my lord, without authority of law and source of power, my lord. And a junior level officer.
Maybe whatever may be the good ground, bad ground, but you have to challenge it.
No, my lord,
My
there is
lord,
no.
my lord, internal page 7 may be seen if my lord, if my learned friend feels that I am wrong, my lord may take internal page 7 of the endorsement, paragraph 2. With reference to the said quarrying lease, my lord gets it. Joint survey report and DGPS and drone survey and as per the report submitted by the technical officer on 15/11/2024, it is found that illegal quarrying, encroachment quarrying and waste has been stacked outside the lease area and violated the conditions of lease. In this background, a report has been submitted to the Director, Department of Mines and Geology to stop. My lord, internal page 7, page 20 of the memo which I filed day before yesterday, my lord.
As per the
8/1/20.
DGPS drone survey?
Yes, yes. Internal page 7.
Yes.
Page 20. Second, we have, the report is forwarded to the director. Let them give an explanation to the director. Though the representative was present, he himself admits.
May I submit, my lords? The last paragraph of that page number 20, I may kindly be, no, either I may be allowed to submit.
No, please, you go ahead.
No, because I am getting disturbed. In this regard, no order oblique direction has been received from the head office. It is hereby informed that after receiving order or direction from head office, further action will be taken. It cannot be said to be either an order or a direction. And moreover, that deputy director has no powers. It is only the director who is the competent authority insofar as specified minor rule is concerned. It appears to be an incorrect submission, my lords. It is without the, secondly, if you go to rule 53 of the KMMC rules.
Whatever it is.
Yes.
This is required to be challenged.
I would submit, my lords, it is not required by virtue of orders passed by this honorable court earlier. 3 orders have produced, my lords. It is at page number 58. I may kindly be permitted to read page number 60, my lords. Page number 60, paragraph number 2, my lords. In the last sentence, of course, if the court permits me, I will read entire. It is not in dispute that the petitioner has been granted 2 mining leases, wide so-and-so, number so-and-so respectively. It is also not in dispute that as of that day, the mining leases are valid and subsisting. As regards the first mining lease, a notice has been issued to the petitioner on so-and-so date, calling upon him to show cause as to why mining lease should not be cancelled for committing violation of the terms and conditions. Full stop. As regards to the second mining lease, similar notice was issued on 28th March 2019, In the said notice, in respect of second mining lease, it is alleged that the petitioner carried out mining activity outside the leased area and therefore is liable to pay penalty of rupees 3 crore 17 lakhs. Now turning to the next operative portion at page number 62, at paragraph number 7, my lords. Page number 62. So long as the mining lease is valid and subsisting, the respondents cannot refuse to issue MDP in respect of mineral lawfully excavated by the petitioner from the leased area. Only on the ground that there is a demand for penalty and that a show cause notice of cancellation has been issued, MDP in respect of minerals lawfully excavated on the basis of subsisting lease cannot be denied. And same view has been reiterated in subsequent annexure F at page number 65 and at annexure G at page number 73, my lord. So in view of this, merely because...
So you mean to say that supposing you violate the terms and conditions, you make illegal excavations by encroaching a surrounding area, or for that matter, make excess excavation of the mineral. Still in that event, because you have been allowed to mine a particular quantum of mineral, you must be given the permit to transport it.
Yes, my lords.
Is it your case?
No, my lord. I will clarify the position. Rule 6(2) may kindly be seen, my lord.
No, see, otherwise the allegation made against you are twofold.
Yes.
One, you have encroached the surrounding area, and you have the allegation made against you.
Yes, my lords. Sorry, my lords.
Or
I agree.
number one,
Yes.
you have encroached the surrounding area and you have excavated much more mineral. I mean, the stone carrying quantity is much more than what is sanctioned. These are the two allegations made against you.
Yes. But my submission is rule 6(3) may kindly be seen, my lords. I may kindly be permitted to read. That is very, very much on the point. Rule 6(3) of KMNC rules. In case of breach of any of the lease or in case of breach by the lessee or licensee or his transferee or assignees of any conditions specified in those rules or in the quarrying lease deed or license, the competent authority shall require by notice in writing the licensee or the lessee or licensee to remedy the breach within 30 days from the date of notice. And if the breach is not remedied within such period, the competent authority may levy a fine of rupees 25,000 in the case of non-specified minor mineral and rupees 50,000 in case of specified minor mineral. Full stop. If a breach of any of the conditions specified in these rules or in the quarrying lease deed or license happens for any subsequent time, the competent authority may levy fine twice the second time and thrice for the subsequent time as mentioned above. What I would like to emphasize is, my lords, first of all, it is only the competent authority. No less than any other than the competent authority can initiate any proceedings. In the instant case, it is the deputy director who has no authorization insofar as specified minor mineral is concerned. This endorsement or whatever that may the learned government advocate is relying is of no consequence.
But still you are required to challenge it because the entire state machinery has sought to act upon that particular endorsement.
That's the reason why I have produced 3 judgments, my lord. Even this subsequently about rule 42, it has been mentioned. That second judgment I may kindly be allowed to be seen, my lord. We will challenge the endorsement if issued by the competent authority. That is different. That is permissible under law, my lord. But this cannot be said to be an endorsement wherein I can take it in the revision because that rule 53 may kindly be seen for a moment, my lord. Rule 53 of KMMC rules, my lords. Revision. Any person aggrieved by an order of the competent court, a competent authority, not above the rank of so and so, so and so. The only thing is, it is the competent authority who has to pass an order. Here, neither there is an order which has been passed by the competent authority where I can take this. It is without authority of law and source of power. No revising authority can take it up.
My lord, may I make my submission? My lord, the endorsement, my lord, maybe it must be wrongly titled as an endorsement. My lord, this report is placed before the director.
This is not endorsement.
My lord, the understanding of the officer, my lord, if my lord were to see the contents, my lord, he brings it to the notice of the director, the violations that have taken place. Violations done by the petitioner. My lord, now this is placed before the director. My lord, the director thereafter will look into it and will have to issue a notice under section 6.3 and then pass an order under, rule 6.3 and then pass an order under rule 8K2.
True, my lord.
We are in the, we
I'm
are
on
in
the
the
only same
process.
point. Till after giving me an opportunity of being heard, a show cause notice is issued and taken to logical conclusion, this much quantity I am liable to pay, then all these things. Till such a time, I may be allowed to transport legally excavated mineral, my lords. I'm not asking anything well within the quarry lease area. Whatever is legally excavated, I may kindly be permitted to transport in terms of the conditions of the lease deed, which has been executed in the name of His Excellency, the Governor of Karnataka.
My lord, rightly or wrongly, my lord, a representation has been given. My lord, that representation has been considered. It is found that there is violation. Now he wants to seek the seal of my of this honorable court to continue with the violations.
No, in that sense,
Hmm.
see, based upon your submission, if that is your submission, then you have to give him time to reply. Before hearing him, you can't.
My lord, my lord, this is just the report. His representative was present. My lord, and it is placed before the director.
If it's only report, where is the question of locking his permit?
My lord, that is because of the violations. We cannot permit violations, my lord, when we have seen the violations.
You have to hear him before doing it, na?
My lord, that is what I said. The report is placed before the director. The director will
Till
issue.
that time, how can you
My lord,
the permit?
then my lord may fix some time, a week. A week, my lord may fix a week's time.
No, you take whatever time that is required, but
No,
how
my
can
lord, we
you
don't
lock
do
his permit?
violations. No violations. We are seeing the violations. I placed it before my lord. The violations, encroachments, excessive quarrying.
But for
That
that,
cannot be under the seal of this court.
correct, but till the competent authority takes such a decision, how can you lock it?
My lord, when there are violations, can we not lock it, my lord?
But the order has to be passed according
My
to you only by the
My lord,
director.
Rule 6.3. Notice has to be given to him, then he will be heard.
Correct, till that time, how can you lock?
My lord may give me some time to see that, my lord, I don't know if the notice has also been issued or whether it is ready.
But my
Okay, you want time, not the authorities concerned.
No, why, my lord? Me means it's the authority. I'll have to verify with the authority and make a submission. Off the cuff, I cannot make submissions.
But my submission, my lords,
What he will verify?
My lord, based on this report is of the is dated 20th December 2024. Today we are, my lord, on 10th of January. Now, what has happened? I have to verify from the director. whether they have looked into this report, whether a notice is being issued or it is ready, then I'll have to make a submission to my lord. Off the cuff, I cannot make submissions, my lord.
My submission is, such a notice has already been quashed by learned single judge, my lords, which I have read in the first instance, page number 55. The very same revenue inspector.
Then it has to be challenged, basically.
No, I will be challenging, my lords, but
How you are.
But only my, in the interim, I may be allowed to operate the ILMS. Otherwise, it becomes almost, it amounts to contemptuous, my lord. Because there is a crystal clear 3 orders.
Would take instructions as to the developments
Yes, my lord.
in regard to the subject matter challenge. Send over to 29th January.
Obliged, my lord.
Can it be little earlier, my lords? Little 1 week earlier, my lords?
Possible.
I will. My lord has directed me and I will see that it is done.
23rd January.
Obliged.
Number 23.
We appear,
CJ Srinivasan.
we appear for the complainant, my lord.
Lords, for the accused, Lords, the order brought under contempt has been appealed against. In writ appeal has been filed against the order brought under contempt, my lords. Writ appeal number 1361 of 2024.
Your lordship may see page number 19, my lord, of the order. The workman is no more, my lord. He has passed away. Only his terminal benefits are to be paid. And we have entered appearance as caveator. They have not even served a copy. Now almost 8 months, my lord, they have not done anything about the order, my lord. They don't even serve a copy of the appeal though we have entered appearance as caveator, my lord.
So when the appeal is coming up?
Appeal date has not been fixed, my lord.
They have not complied with the objections, my lord. They have not even served a copy, though I am a caveator, my lord. They want to prolong the writ appeal and also implement this.
When we will remove the officer?
Lords, may kindly have it any 2 weeks time, my lords.
So stated by learned advocate for the respondent that the writ appeal is filed against the judgment and order dated 16th April 24, learned single judge in the writ petition, which is subject matter of contempt in the present proceedings. Learned advocate further submitted that all the office offences will be removed. Which are all the offices in the appeal shall be removed within 10 days.
Lords, 2 weeks time, my lords.
10 days, remove it, 10 days.
8 months.
10 days from today, the appeal along with the present present contempt petition along with the appeal shall be listed on 24th January.
Please.
Much obliged.
Date is already fixed, on 18th February.
Okay. 24 is adjourned. Seal number 25, Mr. Mohammed Ayed. 25.
For the accused, may I request for a week's time to file my reply in this matter?
Only sufficient time is granted, my lord.
17th February. 17th February.
Much
Taken already sufficient time, my lord, I may.
26.
Much obliged.
Same.
27. The Ranganath S. Joyce.
Lords, in this matter, we have preferred SLP, my lords.
Number 27.
SLP has been preferred, my lords. Dairy number has been given. SLP has been preferred, my lords.
SLP.
Please.
Even otherwise the petitioner is not there. What is some stay is granted?
My lords, SLP number, dairy number is there.
Learned the petitioner is not present. Full stop. Learned additional government advocate state that the SLP is preferred in that field to be listed next on 7th April.
7th April. So number 28. Anuparna Border Life.
Lords, in this we are complying the,
Not been served with a copy.
yes.
My lords, if I may be given a short accommodation to go through the
Photos.
compliance affidavit and file my reply if in, even the,
Complied with then.
Gra-
even the
grant of
council on
query
record
lease.
is,
Court office,
Decision is rendered.
please.
the council on record is also not available today. It may be taken up a short accommodation, my lord,
Additional.
anytime next week, my lords.
And files compliance affidavit to state that the directions are complied with, however, learned education so and so 6 times. Put up on 20th at 2:30.
Obliged, my lord. Very great.
So number 29. Mr. Ranganath R. Number 29, Mr. Ranganath
Here
R.
also we have complied and filed our compliance affidavit.
25th of February.
Same 30.
It's the same matter.
Same. Yes.
Number 31. Okay. Umar E. Farooq.
Same 25th February.
Number 32. Mr. Girish TR.
Not received the compliance affidavit.
7th February.
We have filed. I'll
You are-
serve the copy.
Same for the complaint. madam. I have
Okay.
not received the compliance affidavit.
I'll serve.
It is complied with
It's complied.
Right, kindly have it on next week. I have
to
to.
be listed on 20th at 2:30.
Correct.
In view of the request made by learned advocate for the response. Petitioner.
Number 33.
Right.
Satish K.
Appear for the appellant. Lord, the office objection is, my lord,
But we have complied with the order, my lords.
Yeah.
Like the student is studying.
madam,
Yes. Read up.
I'm sorry.
writ appeal, my lord. The order passed in the writ petition as well as, my lord, review petition is under challenge. Lord, I was arrayed as, my lord, the district officer, backward classes welfare on my official capacity. Lord, thereafter, my lord, I am aggrieved only to the extent that, my lord, the para 3 at page 51. But the issue is, my lord, with regard to, my lord, the issuance of validity certificate. The respond number 1 approaches, my lord, the learned single judge, my lord, contending that her income of, my lord, the parents cannot be taken into consideration for the purpose of, my lord, issuing validity certificate. Validity certificate was not issued. My lord, the appellant is the concerned, my lord, district officer, backward classes welfare officer at the relevant point of time. My lord, writ petition is allowed, my lord, directed to issue the validity certificate, and, my lord, 3 months salary is to be compensated, which shall be from the, my lord, salary of the appellant. Not only to that extent I am agreed, my lord. No, my lord, validity certificate is already issued and she is already appointed. There is no, my lord, grievance insofar as grievance does not survive insofar as the petitioner is concerned. That is, my lord, respond number 1 before my lords. Only to that extent, my lord.
So what is the elementary grievance?
Please, my lord, while allowing the writ petition at para 3 in, my lord,
See, it's dereliction of duty on your part.
But, my lord, we have taken into consideration the income of, my lord, her husband. While, my lord, therefore, my lord, I did not issue, my lord, it is not, my lord, I have denied. My lord, committee is headed by the deputy commissioner. I am a member secretary, my lord. I am not saying that, my lord, I am no way connected. I am one of the members.
See, you either the order has to be challenged or you pay up the money.
But I have challenged the order. Only to that extent, my lord, I have challenged. But my limited prayer in the writ appeal is to set aside the order to the extent of para 15, subclause 3 and 5. My lord, kindly come to page 24, my lord. That is my limited prayer. State has, my lord, in fact, supported before the learned single judge that, my lord, there was no, my lord, laxity on my part. Nevertheless, my lord, no, my lord, the validity certificate is issued, and, my lord, she is already appointed.
So have you challenged this?
But annexure P, page 284, my lord,
Will be taken up on Monday, my lords. Should be kind. I'll take instructions, my colleague.
that is the, my lord, limited prayer.
16th. 16th at 2:30. This is.
Oblige.
Number 34.
I'm appearing for the complainant, my lords. My lords, we have done the needful. We have taken the steps, my lords. We have done the needful. Previously, your lordship had ordered for the notice, my lord. We have taken the steps. We have furnished the same.
So what is to be done?
Your lordship may kindly order for the notice, my lords. My lords, notice may be issued, my lords, and a date may be given for this.
Notice already issued.
My lords, we have taken steps. The needful is done.
Not so. Send over to 7th March.
Number 35. So state appeal.
I'm for respondent number 1 to 4, your lordship. We need to file an objection to IA. Can we, 10 days time may kindly be granted, your
Sir.
lordship. And senior is also not there. He has gone for some death ceremony of some relative.
One submission. Notes, there was a short delay before vacation, my lords, so please to issue notice. They were on caveat. And my lords, University Grants Commission is the respondent number 5. We are permitted to serve Mr. H.R. Shourie. My lords, we have served him. In fact, he had informed that he will appear today. So delay formally may be condoned. 20th, we have scheduled the counseling in terms of the order of the learned single judge. It is matter pertains to, my lords, recruitment of guest faculty to the extent of around 10,000 my lords in the Department of Collegiate Education. Because there is some urgency, my lords, if it could be formally delay may be condoned, my lords, and taken up immediately.
But
Next.
on the basis of the order of the lineage single judge, they have acted upon the order also.
Operative portion at 58. Notes, we are held up around 10,000 guest lecturers are to be recruited. Lots for 23-24 petition was filed. But in the last year, my lords, there was no interim order. We were the guest lecturers have worked. Now for 24-25, we had issued a notification. Interlocutory application was filed.
Learned single judge has directed us, my lords, as per page 58, to, my lords, follow the UGC guidelines insofar as PhD is concerned. But in the earlier round of litigation, this honorable court had permitted us to continue clause 6 of a government order, where, my lords, persons, my lords, who don't have PhD also, my lords, are entitled to be appointed as guest lecturers, because UGC guidelines don't apply for guest lecturers and for regular lecturers, and for contract lecturers, not for guest lecturers, my lords. And that was also the stand. And this honorable court, in the kindly see the operative portion, my lords, of the earlier round of litigation. I'll just show, my lords, one paragraph, page 106. It starts at
Lordship,
page
it may be
95.
taken up on Monday itself, because senior will be coming, it may be taken up on Monday.
Please, let's delay may be condoned so that it could come up for,
Is there?
please, my lords. And Mr. All the original petitioners are on caveat, my lords. Last date, my lords.
Delay we are condoning. Heard learned review with respect to parties. This interim application is filed seeking to condone the delay of 17 days. The applicant is state, therefore, as explained in the accompanying affidavit, the passage of time leading to delay to the aforesaid extent was attributed to administrative reasons and the decision-making process. Full stop. In overall view, sufficient cause is made out, delay deserves to be condoned, it is condoned, application is allowed. Appeal shall be listed on Monday, on 13th, as requested by learned counsel.
But sir, the name of Mr. H.R. Shauri has to be shown for respond number 5, my lords. We have filed the acknowledgement. H.R. Shauri for UGC.
HR sorry shall be indicated on both as appearing for respond 5.
Please, grateful.
It can go to 20, it can go to 7/16.
Please, my lords. It could. Grateful.
Number 36. Sir Nataraj HT.
Petitioners permit, short accommodation for.
My lord, in this I take notice for respondents 5 and 9, my lord.
It's a completely frivolous PI, my lords, with great respect I submit. For 3 years, they've kept it pending. They don't bother paying PF. No credentials of the petitioner. My lords, the PIL rules of this honorable court require the credentials of the petitioners to be given. Kindly see the pro forma affidavit. Petition number 2 and 3 are residents. Who is petition number 1? There's no details at all, my lords. And for 3 years, they've kept it pending like this. I'm for respondent number 12, my lords. And the prayer is to demolish my house, which according to them, without any material, they say that fall within some buffer zone. No material.
So when short accommodation scenery is out of station, sir. Short accommodation scenery is out of station.
I just request my lords to kindly see the pro forma affidavit, my lords, that is at page 19.
There is no interim.
My lord, I take notice for respondents 5 and 9, my lord.
Notice in.
No, notice has already been issued.
Issue.
Notice has been issued 3 years ago, and they still.
We have issued.
Yes, I'm not your lordship, the coordinate bench had issued notice. This is the 5th time, my lord, it has come for non-payment of process fee.
First time money is one, for first time.
Can you see
Not
the order
accommodation.
sheet? Order sheet says 5th time it's coming up.
So on behalf of 5 and 9, you are accepting.
Yes, my lord.
Learned
Government.
advocate, learned additional government advocate Nilo Kharagpur accepts notice on behalf of 5 and 9, therefore no actual issuance of notice is necessary. Full stop. Writ petition may be listed as per the request of the petitioners. Learned advocate. Above. On
16th.
23rd of January.
Obliged.
But could it be 23rd? I mean, Harvard must could be the week after that, my lords. That's not inconvenient to your lordship.
28th of January.
Very great.
This is non-compliance of office objection for second time, number 37.
Yes, for a week's time, my lord.
Vikram Balaji.
So 37, 38. In both the matters, 2 weeks' time is granted to remove the office orders. 3 weeks, 3 weeks, 3 weeks. Dealing with the appeal oblique petition consent shall stand automatically dismissed without reference to or order.
39 for council submission.
This also will not survive for consideration, my lords. This has been complied and will not survive for consideration, my lords. This is allotment of
Since it is
PG
stated
6.
by learned additional government advocates to promote the indication that the contempt petitions will not survive as the directions are complied with. Notwithstanding the objections, the same may be listed.
We have filed the complaint. The order has,
20th,
please.
regular. court.
So number 40?
Lordship, I am for the petitioner.
Consideration, because you have challenged the order in the criminal petition.
Yes,
Stay has been granted by the learned single judge matters.
we have
I am
also
passing
filed
the
a
judgment matters. Appeal for,
compliance.
What do you challenge?
The Director Revenue Intelligence matters seized the exotic animals which was handed over to the Bannerghatta Zoological Park. The complainant sought for release of those animals. The Special Economic Offence Court rejected their application in criminal revision petition, District and Sessions Court, Civil Court. Order for release, which order has been challenged by the DRI, in which this learned single judge granted order, staying the operation on serial number 5 may be seen, matters. 25/9/2024.
Serial number 5.
5 means in the order sheet, just I have passed on. Daily order sheet is serial number 5. Back, yes, issue emergent notice to respond. He has appeared now. He has already placed his objections also in the matter. This and the order impugned in the subject petition shall remain stayed. I appear for the respondent. Against.
So I appear for the state, my lords, respondent number.
Will not survive.
Doesn't survive. Does not survive.
Yes, Mr. It will not survive.
4 minutes.
You have order dated 29/10.
W criminal petition number 12,460 of 23.
In date petition number
12,460 of 2023.
2460 of 2023.
Criminal petition.
Criminal petition. Number 1246/23.
Does not serve for consideration.
The petition will not survive from a state's learned advocate. This spectrum. Yes, we are disposing of.
I am okay with that, Lordship.
Yes.
The pleadings have been completed and the arguments will be over in the next date of hearing, Your Honor.
Accepts this factual position.
The impugned order is in 2023 till today, they have not followed it, Your Honor.
Contempt petition is disposed of as not surviving.
On submission matters, on behalf of respond number 2, I may permit you to file wakalatnama. I will file it during the course of.
If filed within 1 week.
Yes, oblige. Oblige.
Number 41?
So the petitioner might
Arjun
receive a
Rao.
week's time to file a condemnation application. ma'am.
What condonation in contempt?
My lords, my submission was that it is a continuing contempt. Therefore, I may not be required to file a condemnation, but I will. It is just a 2-month delay in filing the petition, my lords.
13th February. Condonation delay.
My lords, in this, what has happened is I'm stating that the contempt is of an order of this Honorable High Court, of this Honorable Court, asking the accused to pay me an amount of 2 crore 20 lakhs. That had to be done within 2 months of passing of that order, my lords. I have come before my lords now, and I had made a counsel submission stating that since it is a continuing violation of the order, since it is a continuing offense,
Lords, it's
So there is no
from
question of
16th
is it
March.
either barred or not barred.
I'll file an application seeking condemnation, my lords.
What is the direction?
Please, my lords. The writ appeal judgment is at page 25, my lords. And the direction is at page 31. 30 and 31.
Have it. 29th of January.
So number 42, to Shrikant Patil. I approach for the complaint in this case. The submission is this in writ petition. Respondent to BBMP Mahalakshmipura division was added as respondent number 2. The direction was issued to them. When I filed an application for change of kata to them, they said, my lord, they don't have a jurisdiction. Now I filed with the accused number 1, who is having jurisdiction to issue kata in respect of subject property. That's the only. In writ petition, my lord, we made a respondent number 2, Mahalakshmipura subdivision revenue officer, to change kata. Direction was issued to them. When we filed an application before them to change kata, they said now the jurisdiction is changed. You have to file before concerned jurisdictional officer, revenue officer. We filed an application before the accused number 1, this complaint. Now, basically, he is not complied the order. That's why, my lord.
Lords, I appear for respondent number 2, my lords.
Notice has to go to them, A1.
So why they are not complying? Change of,
Kata, my lord.
why they are not complying?
The same, my lord, we have sales certificate along with the my lord, sketch. They say it is not registered. You have to file unnecessary documents. That despite there is an order, my lord, as per the sales certificate and also sketch appended to the sales certificate, kata has to be changed. There is a specific direction by the single judge.
In terms of sales certificate of sale and the boundaries mentioned in
Please, 23 is the
notice written on 23rd of February.
published.
Office of dismissal we removed.
Please. Publish. Number 43. Anji Raghavendra.
Lordship, appear for the petitioner, Lordship. I kindly request to pass over the lot matter. Lord.
Pass over today may not be possible, 11th March.
Much obliged, Lordship.
Number 44. Money Vandan.
My lords, with regard to office objections, the accused number 2, a special Tahsildar, on behalf of the accused number 1, Tahsildar, he passed an order disobeying the orders of my lords. My lords, they granted the interim order on 19/8/2024 not to precipitate the matter and the dispute challenging not to change the kata in favor of accused number 3, my lords. And now this the accused number 2 on behalf of accused number 1, my lords, he passed an order on 29/2024 to change kata in favor of accused number 3, violating the orders of my lords. And therefore, he is a necessary and proper party, and he also requires to be prosecuted under the contempt proceedings. Therefore, the objections may kindly be overruled.
If the party is not a party in the main proceedings, how can you?
Yes,
So
my
we are
lords.
liberally in some cases permitting, but technically and even substantially is not.
Now, my lords, he is
How
subordinate.
can you say that when he is not a party, he has committed contempt?
Yes, my lords, he is the person who has passed now the order
Oh.
on behalf of the accused number 1, Tashilda, and both are at the very same office, and the accused number 2 is subordinate to the accused number 1, is a special Tashilda. And now, my lords, the order which he passed, in page number 75, my lords, he refers all with regard to the writ petition order also. And therefore, he had the knowledge. And now, my lords, they granted interim at the instance of the government as well as the accused number 3, my lords, and accused number 1. And therefore, my lords, knowing fully well with regard to the orders of my lords, he passed an order to change kata in the name of accused number 3. Therefore, there is a clear the violation of the orders of my lords.
It's an interim order.
Yes, my lords, the interim order, it 52, it
interim
commences, my lords.
Not to precipitate.
Yes,
19/8/20,
Page 53.
page 47.
no, 53, my lords. It commences from 52, and date of order is on 19/8/2024, my lords. The page number 23. In that view, however, while granting time to accede to the request of the respondents to list the appeal, next on 13/9/2024, it is provided and directed that the subject matter shall not be further precipitated by the parties concerned.
So interim order, the order dated 19/8/24, which is brought under the contempt jurisdiction, is admittedly in interim order, passed in the pending writ appeal. Full stop. When the main proceedings of appeal are pending, it is obvious that the rights of the parties are not finally crystallized. Therefore, in that view, the court is not inclined to invoke the jurisdiction under the contempt of courts act 1978, leaving the petitioner to work out his
No, my
rights and
lords.
remedies before
No, my lords.
the proceedings of appeal.
No, there is a clear violation, my lords, the orders of my lords. There is an order not to change the kata, my lords. That is what disobeying the orders of my lords, the kata
Unless
is changed now, my
There
lords.
is no tripping of finality in the order. Which may.
No. Your lordship may kindly take up page number 75.
We are not entertaining the contempt against the interim order unless there is some element of finality.
There is a clear violation of the.
Go before the same bench and
My lords,
work out.
lordships granted interim order not to change kata, my lords. Now that
Sorry,
45. Keshav Datta.
at least lordship may kindly refer this matter for adjudication to the trial court, at least, my lords,
we are
for
not
recording evidences.
not invoking contempt jurisdiction. You pray before the bench in the appeal.
My lords, your order is violated, my lords. There is a clear order not to
But we are
precipitate the
we'll
matter,
be
my
dealing
lords.
in appeal, not in contempt jurisdiction. We'll deal with in appeal.
If that is so, my lords, liberty may kindly be granted to make an application in appeal itself. at
It's
least.
already there. It is already observed. Liberty to work out rights and remedies in the proceedings of the appeal.
In the appeal, my lords, please.
45.
The office objection is that the deputy commissioner is not being directed by the learned single judge. The deputy commissioner has not been directed to consider the representation. But the deputy commissioner is the person who has to fix the land, the property tax for the scheduled property. So therefore, he is a proper and necessary party. That is the office objection where I've written your lordships could have section 84 minutes. We are asking them to fix the property tax and consider my representation.
So what is the office objection?
Office objection is that accused number 1 has not been directed by the learned single judge, but accused number 1 is still a proper and necessary party. The only reason being that he is the one who has to fix the land revenue in terms of section 84 of the Karnataka Land Revenue Act.
Direction is to respondent number 3. direction is issued to the Tashildar.
So what is your
Now-
response?
Deputy Commissioner is made the accused. What's therefore the
No,
officer?
no, respect to direction itself now.
My lords,
Are you going to consider this? Tehsildar will be considering this or not?
that's it's listed in office objection. I'll take instructions, my lords.
There is a direction.
There is a direction to third respondent, the Tashildar.
See, what happens when the writ petition is being heard? Neither the petitioner or advocate take the necessary strain to find out who is the person involved. It's incompetence on your part.
Minutes.
And then the government advocate also will not apprise the court regarding who is the concerned officer to whom the direction has to be issued.
Please.
The court, upon hearing the matter, going through the records, comes to the conclusion, yes, the right of the petitioner is violated and a direction is issued.
They'll have to seek.
And direction is issued to the Tahsildar. Okay, but nevertheless, it's a direction issued to the government to redress the grievances of the petitioner. Suitably instruct your officer concerned.
Obliged.
See, on your part also, you have to be careful as to who is the concerned officer. The court will not be knowing it.
I bow down, my lord.
We rely upon the submission made by the advocates and issued the directions.
Obliged.
So just positively respond to this. So
Obliged.
that we may not to go to these miscellaneous.
Very well.
28th of January
Obliged.
to be listed at 2:30.
Grateful. Minutes.
And learned additional government advocate, Mr. Kishan would apprise the court about the implementation of the code.
My lords, there are similar matters, my lords, that are also pending. Contempt petition number 1181 of
Get it listed on a day and we'll
on the
then-
same day, my lords.
On the
It
same.
could be tagged because they are similar.
Get it listed.
Grateful.
Posting. Member for posting. 46, 47 are urgent, number 48. The BK.
Appearing for the petitioner in this, kindly pass over, my lord. Senior is arguing a matter in 16th court hall.
Maybe some other day we'll keep.
My lord, then I will submit what is the office objection along with the council submission.
This is what seal number
This-
748.
Contempt, respondent number 4 and 5 has made as formal parties, my lord, because they have to give the direction to the accused number 1 and 2 for the registration of the apartment complex under 1972 Karnataka Apartment Ownership Act, my lord. On 22nd August, we have received an order through a writ petition to register the apartment complex under the Karnataka Apartment Ownership Act, my lord. There was similar case also yesterday that CCC 1059 of 2024.
Take instructions, my lord.
Notice returnable.
No.
They are not made parties by name.
They have made us formal parties, they have made us in respondent number 4 and 5 has made us
In
formal.
contempt, it is always by name, Mr. Counsel. No. Yes. You are state of Karnataka. And you are government of INC. Number 5. I'm sorry, 4. Register.
1 and 2. By name, 1 and 2.
1 and 2 is by name we have given, my lord, because they have to accuse number 1 and 2, the names we have given.
2 and 3. But 4 and 5.
4 and 5 are the formal parties, names are not yet mentioned, we'll do the needful, my lord.
So 1 and 2 are the.
The
Accused,
please.
So office objection is dispensed.
obliged.
Then what is the direction? We issue notice that things go on more.
To register the deed of
It is
declaration.
returnable on. We'll go to February 20th.
Obliged.
Number 49. The Murugesh V Charity.
For the appellate in the appeal. filed by the Bangalore Development Authority. Lord, against the order of the learned single judge, your present appeal is,
Delay.
please, Lord, there's a contempt petition filed by the respondent. Learned friend can accept notice for the respondents, not the contempt is filed by them. The petition, original petitioner has filed a contempt.
So notice in delay application.
Yes, I have complied.
Automatically, writ appeal will be grant dismiss.
Lord,
Even today, they have not complied the order of subject.
I have complied the office objection, Lord, insofar as the Lord, I have made a note with regard to Lord, the extract, Kannada extract in the order copy of the learned single judge, Lord, I have sought for a dispensation of translation of that. Lord, you may kindly
There is
take
a
page.
clear order by the Honorable Court. Comply the order. Automatically, writ appeal will be grant dismiss.
How can that dispense with? That has to be gone in. That has to be gone into, how can that be dispensed with?
What do you want to dispense with?
Lord, I am seeking for a dispensation of Lord, the translation portion of page 16, Lord, there is an extract by the learned single judge in the Kannada portion.
But that is part of the judgment that has to be gone into and appreciated while deciding the appeal. How can that be dispensed with?
The
And
content,
then it's 4 lines, can't you?
yes, I'll do that.
That's
Lord,
correct. So
I'll do that.
do it within
Keep the
10.
time. First request for 2004, there is a clear direction by the Honorable Court in 4 writ petitions.
On or before the office of petition regarding on or before 27th of January, the office of petition regarding translation in English shall be complied with. The appeal shall be listed along with the contempt petition on 29th of.
So take notice,
Please.
let him have the copy of the
Entire writ petition is decided based on this observation. And the entire writ petition is decided based on this observation, which is in Kannada, and you want it
No,
to
no,
be dispensed.
Lord, that is not the crux of the matter, Lord. The
Then
learned
what
single judge.
part of the order is it?
The learned single judge has directed us to release the land in favor of the petitioner when the land stood vested. Vesting is admitted. Lord, and this is the second round of a litigation which he files on the very same cause of action. Lord, the learned single
There is
judge.
a submission.
Yes.
There is one submission made by the my learned friend.
And then
Let
now
me furnish the copy of the writ appeal.
He'll be-
Kindly direct him.
will be complying next.
Please.
Number 50, Mr. Prashant PN.
Partition was affected between the parties, my lords, brothers. Subsequent to partition, my lords, one of the property that fell to the share of the petitioner was sold by him. Thereafter, a legal notice was issued, my lords.
So delay is there 74.
Lords, I am not a party to the writ petition, my lords. It's kind submission, my lords. One submission I'll make,
Then
my lords.
notice will have to go. Notice written.
Lords, what has happened, my lords? The suit, he has taken a direction for the suit to be completed in 6 months, my lords. The suit proceedings are going on day-to-day proceedings, my lords. The khata was standing in the name of the appellant, my lords, in view of the partition deed affected. Now he takes an order, my lords, without arraying me as a party, that the khatas to be the joint names. Now, my lords, he has placed those joint khatas, my lords, subsequent to the judgment before the trial court and been marked. Entire rights have been affected, my lords. There is a partition affected. Subsequent to the partition was, he has filed a suit. All those things were suppressed before the lower court. Partition suit has been suppressed. Suit has been suppressed.
So
The,
this is leave to appeal.
my lords,
Leave to appeal. You are not party.
I'm not party, my lords.
So this is for leave to appeal.
Please, my lord.
So there is a delay in 74.
Please, my lords. I came to know, my lords, subsequent to the filing of those, my lords.
Lord, for the respondent authority, my lord, I have nothing in this. They have, there are 3 sons and 1 daughter. One of
Then
them has
notice will
given
have to
an.
go even in leave to appeal. Notice returnable on.
Till then, my lords, because till then, my lords, let the order
No.
pass, my lords. Because it's a suit, my lords, where he has
Third-
taken an
third
order,
Feb-
my lords.
3rd
My
February.
lords, I may be permitted to serve a copy on the advocate appearing for the lower court, my lords, at
That
least.
you can do that.
And next week, my lords, if possible, my lords, please request, my lords. I'll serve a copy on the advocate, my
What
lords.
is that urgency, dire?
Urgency is that, my lords, direction has been taken for the suit to be disposed in 6 months. Every day the proceedings are going on, my lords. He has placed those documents as marked before the trial court. Subsequent to the order, my lords, the joint katas has been marked there. Yes, sir. Giant kata has already been issued by the commissioner, my lords, in view of the order passed by the court. And he has placed those joint katas before the trial court, my lords.
First person is Chandrasekhar, party in person. He's a caveator respondent. He has filed a caveat petition. It's supposed to be here.
The whole suppression of facts, my lords.
So then inform the party in person, so it can be dealt with effectively if he is here.
My lords.
Party in person, number one is party in
And
person.
for the respondent BBMP, my lord, I have nothing.
Caveat has been-
It has been returned, my lords. That CP has been returned because of defective, my lords.
He's supposed to be here, that's the reason. Because
So since party in person,
Is
since this one party in person is not present, the proceedings are adjourned to 21st.
21st. May I be permitted to serve a copy on the advocate, my lords, appearing for the lower court?
No, he has filed.
Party in person.
Please, my lord. Grateful, my lords.
He has
21st.
filed a caveat. party
Please,
in
my lord, that
person.
has been returned, my
You
lords.
served the copy to party in person.
He's not taking, my lords. We tried to call him, my lords. He's not picking the call, my lords.
Stand by registered.
We tried to call him, my lords. I'll send RPD, my lords. I'll send
Can you
RPD.
try and serve by registered post?
Yes, my lords. Grateful, my lord.
Right.
51 disposed, number 52, to Suresh TS.
Lordship, two office objections. One, we would not be relying on, it's a bank statement which is irrelevant, Annexure N. Annexure P, which is the lease, Your Lordship. Certain pages which they felt were not very clear, we've already given the typed copies, Your Lordship.
Office objections are dispensed with and of liquor are complied with.
Your
Therefore, the registration list, the writ appeal on
Your Lordship, there's an urgency. This, Your Lordship's order has been again not complied with, Your Lordship. I've annexed it.
when do you want
Second round of it, Your Lordship.
listed on 24th of January?
Lordship, any day, 15th, 16th, Your Lordship.
So what
Request,
is
Your
that?
Lordship. Please, Your Lordship.
What is that urgency?
The urgency is that the lease, they have not even cancelled. Again, they've said stop work. On the last occasion, the government said, yes, it can go back for further hearing. Lordship had given specific instructions on what they must do. They have not followed, and the same order again has been passed, Your Lordship. Again, asking us to stop work without any reasons.
20th.
Please, obliged to.
53. Yes. 53. more.
Same, Your Lordship.
Same.
Lordship,
So
there's already a
so-
direction that
Pardon?
there was already a direction that the government could seek instructions and mention it. This was already directed on the vacation bench itself, Your Lordship.
Take instruction in those.
Obliged.
What is this one? Draw, no. I complained with him. Is there there? They are withdrawing.
List number 2, seal number 1, Mr. Shankar Narayan Bhatt.
They have filed it.
We have filed the compliance affidavit, my lords, this matter.
Order has been passed, Mila, but not in time. But after 1 year, the order.
There is
Yeah.
an addendum amongst the learned advocates appearing for the petitioner as well as the respondent that they already.
They have
complied
cancelled the grant also in the,
with
while in the
that
course
with
of
the
that.
contempt
But they're
petition.
separating
Does
right.
not survive and is dismissed according.
Number 2, Mr. Harish HB.
Yes.
So in this also, we have filed our compliance.
Lordship, there's only partial compliance of the order which is being passed. There are few other orders which has been not complied by the assistant commissioner as well as the respondent. We have actually we have to file a rejoinder affidavit. But Your Lordship, the urgency is that he's a senior citizen of 92 years old. He's a senior citizen of 92 years old and he's residing in an ashrama. So he wants to spend his rest of his life in the house he built. And that was an order which was being passed, which is not complied. So a shorter date, if accommodated, I will be filing the rejoinder.
Outer date,
Sure.
23rd January.
Please, Your Lordship.
Number 3, AC Balraj.
My lord, endorsement has been issued. Liberty may resort, my lord, to.
The endorsement is already issued as stated fairly by learned advocate for the, which marks compliance of the directions of the court, which are made subject matter of contempt in this petition. In that view, the contempt proceeding will not survive, it is disposed of accordingly. Liberty is reserved for the petitioner, challenge the endorsement on merits.
Please.
If so advised, however, this court does not express any opinion on the merits of such challenge.
Seal number 4, Mr. Adi Narayanappa.
So 20th at 2:30.
Seal number 5, Mr. Ranganath R.
Same, 20th at 2:30.
Seal number 6, Mr. Vinod Kumar K.
Same, 20th at 2:30.
Seal number 7, Mr. Manjula Kamadoli.
Same.
ಅಲ್ಲಿರ್ಲಿ ಮೇಡಮ್. ಸರ್ ಕಲಬುರಗಿ ಬೆಂಚ್ ಪೋರ್ಟಲ್ ಒನ್ನಿಂದ ಇಲ್ಲಿ ಹೈಕೋರ್ಟ್ ಬೆಂಗಳೂರು ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಸರ್? ಕೋರ್ಟ್ ಆಫೀಸರ್?
ಹಾ ಸರ್ ಕೇಳಿಸ್ತಾ ಇದೆ.
ಹಾ ಸಾಹೇಬ್ರು ಬರ್ತಾ ಇದ್ದಾರಾ?
ಹಾ ಸರ್ ಬರ್ತಾರೆ.
ಓಕೆ, ಬಂದ ತಕ್ಷಣ ನೀವು ಒಂದು ಸ್ವಲ್ಪ ಇದು ಮಾಡಿ ಅನ್ಮ್ಯೂಟ್ ಮಾಡಿ ಮಾತಾಡಿ. ಇನ್ನೂ ಬಂದಿಲ್ಲ ಸಾಹೇಬ್ರು ಅಂತ ಹೇಳಿ.
ಹಾ ಸರ್.
ಇನ್ನೂ ಬಂದ ತಕ್ಷಣ ಫೋನ್. ಇಲ್ಲ ಬೇಡ, ನಾನು ಹೇಳ್ತೀನಿ, ಇನ್ನೂ ಬಂದಿಲ್ಲ ಸರ್.
ಮೇಡಮ್ ಸಾಹೇಬ್ರು ಬರ್ತಾ ಇದ್ದಾರಾ?
ಬಂದಿಲ್ಲ ಬಂದಿಲ್ಲ. ಇಲ್ಲೇ
ಬಂದ್ರು ಸಾಹೇಬ್ರು ಬಂದ್ರು.
ಹೇಳ್ಬಿಡಿ. Pronouncement of order in the review petition 481 of 2023.
Yes, brother.
Yes, sir. The review petition is dismissed in view of the dismissal of the main petition pending interlocutory applications, if any, do not survive for consideration, accordingly disposed of.
Obliged.
Much.